Welcome back to Law and Society. We're going to take on one topic today. It's a very interesting topic. It's search and seizure, and we could spend a lot of time on this. But I'm going to give you a very brief introduction to it, and then I'm going to have you read something. You're going to stop the screencast and do a little reading for a few minutes, and then come back and finish. So we started when we were looking at criminal law. I said that in the criminal justice system, there's always a balancing act between the need to protect the society from harm and then the individual rights that people have. So, how much can you take away individual rights, for example, to protect society? And that fits in beautifully with when we're talking about search and seizure. Also, remember that we have three components in the criminal justice system: the police, the courts, and corrections. And then I said to you, we don't really have any agreed upon goals in the system, but I showed you these earlier too, that these came from a 1968 law, the Crime Prevention Act, uh, that they're probably the closest thing we have to agreed upon goals within the system. Okay, so keep this continuum in mind here as we get into search and seizure. So, do we have a right to privacy explicitly granted in the Constitution? Okay, if we were in class together, face to face, and I used to do this with my students, I'd have them pull out the Constitution or look up the Constitution and find the word privacy in the Constitution. And I would let them go with that for a few minutes. And of course, it was a trick on my part because the word privacy is not in the US Constitution. That's kind of the interesting thing about that. It's basically implied in two places. And I think American people, we all cherish our privacy. We think that's an important thing in our culture. And we think about it, I think, even more today with the digital world that we're living in. But it really isn't explicitly granted anywhere in the Constitution. That's the interesting thing. So implied, meaning it's not stated outright, but we can imply that we have privacy by looking at the Fourth Amendment. Okay, everybody take a look at it with me. The right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. Remember those levels of proof, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, this is the amendment we're kind of focused on today as we look at search and seizure. There's a lot of things in there. You're going to read about that more in a minute. Now, the word privacy isn't there, but you can see the implication of privacy, all right? It's also in the Ninth Amendment. And the Ninth Amendment is an amendment we never talk about very much. This is about the only time we ever talk about it, or that I would ever talk about it in my classes. I'm just going to read it to you, and I have a couple of words interjected in there to kind of help you. The enumeration in the Constitution, that means if things would be listed, enumerated, listed out. The enumeration in the Constitution of certain rights shall not be construed, meaning interpreted, to deny or disparage. Disparage would be to take something away. Others retained, meaning held, by the people. So let me read that again with all that choppiness on my part. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. All right. In other words, just because a right isn't listed in the Constitution, it doesn't mean we don't have that right. Okay, in our system of government, we tried to really have a generous gift of rights to the people. This was something from the very beginning of our history. And the Ninth Amendment then is often cited as the implied right to privacy. Privacy isn't listed, but it's implied in this amendment. It's implied in the Fourth Amendment. Okay, so kind of keep those things in mind as we go along. All right. So what's a search? Well, a search by definition, is an invasion of privacy. So if somebody comes in, wants to search your home or search your car or search your garage or whatever, we live under a so-called reasonable expectation of privacy doctrine. That's something in the law of the country. In other words, the Fourth Amendment does not protect against all invasions of privacy. It only forbids unreasonable searches and seizures. Okay, so the question then is, what constitutes a reasonable search? See, that's very loaded language, isn't it? That word reasonable. There's a lot of ways you could interpret that, or unreasonable. You can see where interpretation comes into play. You can see how important it is, what courts determine the Constitution actually is saying. All right. So what I want you to do right now is stop the screencast, go back to the announcement that I sent out. There's a link in there for a reading by a guy named Professor Stevens. And I'm just going to give you a quick description and then you can go ahead on it. The first 2 pages of it define what we mean by the word search and what we mean by seizure. So the beginning of the reading is going to take you into that area. Then starting on page 2 on the bottom, he outlines exceptions to search and seizure protection. In other words, under what circumstances do authorities have the right to search? And he documents 15 of them. Okay. Now you don't have to read through all of them, but you can skim a few of them and you'll see that there's a lot of exceptions to search and seizure. Search and seizure law has been sort of blown up, especially in recent years, and we'll talk more about that. So read that, take a few minutes on it, and then think about this while you're reading it. What conclusion can you draw from the reading about the various exceptions? And what does it tell you about the Fourth Amendment? And why do you think this has happened? Okay, take some time, stop the screencast, go in and check that reading out, and then come back. All right, so then I'm going to finish by you've got that background reading now, and you're going to do a little more. I've got something you're going to watch, a short YouTube video, and then you'll be answering some questions. I want to just say a little bit about search law in schools. It may not surprise you for me to tell you that you don't have in school as a student, you really don't have Fourth Amendment rights. And that's really interesting because when I started teaching, which is now 41 years ago, you did. I'll give you one example of that. If an authority was going to search your locker during the school day, when I started teaching, they had what was called the in-presence requirement. You had to be present when that was happening, okay? They could not just go in and randomly search your locker willy-nilly. Today, of course, and if we were in school, I could say this doesn't apply right now when we're all at home, but they could be searching lockers anytime during the day and you wouldn't even have to know about it, right? And I think you all understand that. You've kind of grown up with that. So the first real important privacy law in school, Fourth Amendment case, was New Jersey v. TLO. That's the TLO case is kind of the big one. And it has the facts of the case are interesting. I'm going to have you watch something, a little something that'll talk about TLO. But essentially, it was a search of a student, and the student protested the search as a violation of the Fourth and then the 14th Amendment, which made it applicable to the states. And the court said, no, the search was fine. And I'm going to just read the wording to you. No, citing the peculiarities associated with searches on school grounds, the court abandoned its requirement that searches be conducted only when a probable cause, remember that's a higher level of proof, exists that an individual has violated the law. The court used a less strict standard of reasonableness to conclude that the search did not violate the Constitution. The presence of rolling papers in the purse gave rise to reasonable suspicion in the principal's mind that TLO, they used just the initials of the student, may have been carrying drugs, thus far justifying a more thorough search of the purse. Okay, take a look at the date on that case, 1985. We were right in the middle of something at that time under the Reagan administration. I was teaching called the War on Drugs. The War on Drugs. Just say no, Nancy Reagan. Just say no. The War on Drugs. You can look that up, Google that if you want to. The War on Drugs opened the door for much more open searching of students on school grounds. There's no question about that. Okay, that's context for you. All right, let's take another one. How about drug testing athletes? That's an interesting one. Um, does that violate your Fourth Amendment rights if you had to do a random drug test in order to participate in a sport? Right? It's a really interesting question, isn't it? And basically, in 1995, the court said, no, the reasonableness of a search is judged by balancing the intrusion on the individual's Fourth Amendment interests against the promotion of legitimate governmental interests. Legitimate governmental interests. In the case of high school athletes who are under state supervision during school hours, they are subject to greater control than over free adults. The privacy interests compromised by urine samples are negligible, since the conditions of collection are similar to public restrooms and the results are viewed only by limited authorities. Furthermore, the governmental concern over the safety of minors under their supervision overrides the minimal, if any, intrusion in student athletes' privacy. Isn't that interesting? In other words, this was another example of where the Fourth Amendment was just kind of blown apart when it came to students on school grounds. One more. Board of Education v. Earls, 2002. Is the student activities drug testing policy, which requires all students who participate in competitive extracurricular activities to submit to drugs testing, consistent with the Fourth Amendment? And they said again, yes. In a 5-4 opinion delivered by Clarence Thomas, the court held that because the policy reasonably serves the school district's important interest in detecting and preventing drug use among its students, it is constitutional. Okay, I could show you many more cases about school and search, but I didn't even bring up the fact that after Columbine, post Columbine, we've seen even more wide open search possibilities in schools of students, because so basically it's been drugs and weapons that have caused this to change. And I kind of have mixed feelings about it as an educator. I'm kind of a constitutionalist, and I feel like this really does in a way violate the Constitution, but the society has been willing to accept this, and courts have reflected that view all the way along. All right. So that's a little bit of background for you on search and seizure. You're going to be watching a video now, and then you'll go into the assignment and do a few written prompts for me. I hope it's going well for you. And until next time, good luck.